with a complement of 50. The fourth respondent therefore failed to exercise its exclusive constitutional mandate under Article 230(4)(a). Further, that the fourth respondent, in its letter dated 14th March 2023, had advised for a higher gross monthly salary to that of the PS with no justification, as is clear from the Kenya Gazette Notice number 8792 of 2022. The second respondent submitted that the legislature has the power over public finance and the independent offices of the Control of Budget and the Auditor General to report to it. These are the offices that should determine the issue of wasteful spending. The fourth respondent submitted that the advice by the fourth respondent on remuneration and benefits for the CS was issued within their constitutional mandate under Article 230, Subarticle 4(b) of the Constitution and Section 11 of the SRC Act, and not the SRC Regulations 2013. The advice was thus based on an objective and fair process which took into account the principles outlined in Article 230, Subarticle 5 of the Constitution, and the job descriptions by the fifth respondent. The first interested party submitted that under Article 228, 4 and 5 of the Constitution, it was not responsible for paying remuneration and benefits to the CSS or any other state or public officers following their mandates under Article 228 of the Constitution. We also note that the initial CAS office, as established in 2018, was graded under Job Group U, and the appointed persons were to enter at the midpoint of the salary scale. After this office was abolished and a new one established on 11th of October 2022, the position was graded under Job Group CSG3 in the public service. The gross salary is above 700,000 shillings plus other emoluments as seen from the letter from the fourth respondent. The second respondent, with reference to the 27 additional CSS, made known that their financial provision was given the green light by the National Treasury, which indicated that there was sufficient funds to cater for the additional numbers. We referred to Article 230, Subarticle 4 of the Constitution, which provides for the powers and functions of the SRC. Further to the above, Rima J in the Okia case found that failure to involve the fourth respondent on the financial matters of the CS office was a serious omission, rendering the establishment of the said office unconstitutional. It is therefore clear to us that the fifth respondent should have consulted the SRC in order for it to ascertain the resultant financial implications. A related issue arising within the context of the various financial implications is the question of whether this court can make a decision on budgetary issues. The court in the case of Wanjiru, Gikonyo and two others, expounding on this issue, opined as follows. By justiciability, it is meant a matter proper to be examined in courts of justice, or a question as may properly come before a tribunal for decision. A court must satisfy itself that the case before it is not caught up by the bar on non-justiciability. The concept is comprised of three doctrines. Firstly, the political question doctrine. Secondly, the constitutional avoidance doctrine. And thirdly, the ripeness doctrine. It is our considered view that based on the separation of powers doctrine, budgetary concerns fall within the realm of policy and rightly belong to the other relevant arms of government as may be appropriate. We thus decline the invitation to delve any deeper into that arena.
I'll now ask my honored brother, Justice Alem Fisram, to deal with the next issue.
The next issue is, was the President improperly enjoined as a party to the proceedings? The second to the fifth respondent submitted that the first respondent was improperly enjoined the present consolidated petition. The petitioners on their part did not oppose the said prayer, but contended that the misjoinder was not fatal to the consolidated petition. Having considered the submissions of the parties on this issue as set out above, we are guided by Article 143 of the Constitution and the decision of the Supreme Court in, and I will not read the full citation, but more commonly known as the BBI case, where the following paragraphs the court stated as follows, and here I will only quote the relevant paragraphs because we have quite a long quote. Anybody or any party aggrieved by the President's actions or failures can initiate proceedings against the Attorney General, who by virtue of being a legal representative of the government in legal proceedings also represents the President, who is the head of government. The immunity, on the other hand, offers protection that shields the President from civil suits being filed against them in their personal capacity. I will further quote, as such, pursuant to Article 156(4) of the Constitution, the exercise of public power by the President can be challenged in the court of law by suing the Attorney General through an action of judicial review or constitutional petition, wherein the court may issue appropriate reliefs. This leads me to the conclusion that the learned judges unfortunately fell in error in their interpretation and application of Article 143(2) of the Constitution by holding that civil proceedings can be instituted against the President or the person performing the functions of the office of President during their tenure of office in respect of anything done or not done contrary to the Constitution. Pursuant to Article 143 of the Constitution and based on the law as set out above, we find that the first respondent was improperly enjoined to the consolidated petition. We further find that the misjoinder is not fatal to the consolidated petition, but take the opportunity to urge the petitioners and future litigants to avoid this practice in light of the unequivocal pronouncement by the Supreme Court on this issue.
Thank you. I'll now ask the Honorable Lady Justice Hedwig Ngudi to deal with the next issue.
The next issue is whether the consolidated petition was drawn with sufficient precision. In a constitutional suit, a party that alleges violation of his or her rights must plead with reasonable precision the manner in which the rights are being violated. We have a number of authorities on this. And our interpretation of the above provision is that for a constitutional petition to be sustainable, it must satisfy the threshold set out in the authorities we have cited. It therefore follows that the mere citing of constitutional provisions is not enough. The petitioners must, with some reasonable degree of precision, identify the constitutional provisions that are alleged to have been violated and the manner in which the said provisions have been violated from the facts and the evidence of the case. In the circumstances of this case and material placed before this court, we find that the above threshold has been met by the petitioners. And the next issue is on unpleaded issues raised in submissions and supplementary affidavits. The second and fifth respondents and some interested parties opposed the introduction of new issues and new prayers as raised by the third petitioner in its supplementary affidavit dated 5th of May 2023 and the second petitioner's further affidavit dated 2nd of May 2023. The second respondent submitted that new issues were also added in the submissions of the second and third petitioners in paragraphs 39, 54, 56, and 56. The fifth respondent challenged paragraphs 14 to 20, 29 to 31, and 43 to 50 of the third petitioner's supplementary affidavit, and paragraphs 29 and 33 of the second petitioner's further affidavit. The 2nd to 7th, 9th to 18th, 20th, 21st, 23rd to 30th, and 33rd to 51st interested parties also challenged the admissibility of evidence in paragraphs 13 to 17 and 33 of the second petitioner's further affidavit, and paragraphs 18 to 33 and 36 in the supplementary affidavit of the third petitioner. The 19th interested party also challenged the admissibility of the evidence in paragraphs 14 to 20, 29 to 31, 33, 43 to 50, 59 to 61 of the third petitioner's supplementary affidavit. Counsel emphasized that the record should reflect that they had no opportunity to reply to the new allegations